Hello, everyone. We are in part two of Unit 3. In part one, we learned about the three elements required for a valid contract, and that was offer, acceptance, and consideration. And in part two, we're going to learn about what we call defenses or other things that could prevent you from having a real contract. So, what we're going to start with is Chapter 13, Real Consent. And when we talk about consent, what we're talking about is that promise and that acceptance, that mutual agreement that the parties made. It has to be mutual and voluntary. So if it's not, then they don't really have consent. They've said yes outwardly. They may have even appeared to have entered into a contract from a third person objective standard, but they weren't given all the information, or some of the information wasn't accurate, and or they believed the information to be something it wasn't, and so they really couldn't give consent. And so sometimes we call that real consent because you really didn't consent. And things that fall under that are duress, undue influence, fraud, misrepresentation, mistake, and you have mutual or unilateral. We're going to go all through these, and we're going to go through the elements. Be sure to download the worksheets because we're going to do them in pairs, because their duress and undue influence are similar, and fraud and misrepresentation are similar, and mistake, we have mutual and unilateral. So get those sheets out so we can write our elements down. So duress versus undue influence. Um, what you need to remember is that with duress, you have coercion. So make sure you put that under the elements. It's coercion. You feel as if you don't have a choice. This is where you think of someone threatening you financially, or threatening to expose you, and they use that in order to coerce you into a contract. What you need to keep in mind with contract is there are other torts that could go with it too, right? So someone could actually have you and keep you in a room, and you have no way out till you sign the contract. You would be able to claim duress because you were coerced, but you'd also have against them the claim of the tort claim of false imprisonment. What we're talking about in that situation is, how do I say that contract is not good? And what we do is we look to see if there was coercion. Undue influence is persuasion, and we think of this when we think of somebody using their power over you to just kind of persuade. And sometimes it's even sweet talk. Hey, would you really want to do this? And you just keep persuading them and persuading them, okay? Both of these situations, the contract, the result could be voidable. So that's what you're going to put under consequences for these. Voidable. What does that mean? One person who was the person who was coerced or persuaded unduly can void the contract. So let's look at duress. Duress is the conduct had an improper threat. The victim had no reasonable alternative but to enter into the contract. And so you may want to go back or pause on that. I should have told you to write those down under your elements. We're going to talk about a case here that's an example. We have 4 years of marriage. Grady and Joyce decide they're going to divorce, so they get into a settlement agreement. And Henley is going to receive 440-acre farm, furniture, cattle and horses, and automobile, and most of their assets, which they could trace pretty much back to her. They entered a decree of divorce, and it's all settled. So that's a contract, it's settled. However, Duncan goes to Hensley's place of employment, and he threatens her life if she did not sign over all the assets that she had received under the terms of agreement. So their agreement was that she'd get the assets, but he's saying, no, you're going to sign them over to me. And he threatens her, okay? And so she relented and signed the instruments conveying the land and animals and the tangible items to Duncan. And then she files a lawsuit to cancel the signed instruments saying I was under duress. So the court has to decide when she signed those instruments over to him, which would be a contract in some ways. When you think about it, if he didn't give her anything in return, it's really not consideration. But at this point, regardless, what she did was under duress. So we're looking at what qualifies for duress. And in this case, the court said if they're achieved by fraud or a duress to prove the judgment of the signer are avoidable at the request of the aggrieved party, right? Only the aggrieved party. And so there was a record of violence that they looked at when they looked back at the case regarding Duncan, and he threatened her at her workplace, and they put her in such fear that she actually signed the papers over to him. There was no other reason. And so the court said that was enough for duress, and therefore the contract is voidable, meaning she can rescind her signature on those instruments. Undue influence. Persuasion is needed, okay? And this is what there's a relationship between the parties and it's on trust or competence, and one person exercises that persuasion and dominates the person being persuaded. And it's really an unfair persuasion. So here is a classic example. Before you flip to the next slide, make sure you get your elements done. Okay, we've got this dance studio, and there were about $30,000 worth of dance instruction to this widow, Siester. She's in her late mid 60s, and there's this charming young dance instructor, and he says, you have this potential to become a professional dancer. And she didn't make any improvement with her dancing, but they kept selling her, saying, hey, you can be a professional dancer. So at trial, it actually was showed that this was a method of the company to aggressively and purposely lead their clients to believe that they had a future so they could sell them on this. And they fired the dance instructor that Siester had. And so she was upset and she started this suit against the company. And so the company said, well, we're going to rehire this dance instructor to see if we can sweet talk her some more. So Siester comes back and he gives her a lot of persuasion. It's constant persuasion, and she drops the suit. And the company then had her sign a release of claims against them, and they said, you're going to get $6,000, and that's the last batch of her instructional lessons, okay? And 2 years later, the company said, well, we want you to go ahead, and they had paid her some money, but we want you to relieve the rest of the obligation. And so she did. And she, again, was like, wait a second, this is all fraud and misrepresentation. So she goes to court and sues them for not only actual damages, for not only what they were supposed to pay her with what she wrote, but by coercing her, persuading her into entering new contracts with them. And the court also gave her $40,000 in punitive damages. So when the question was, are the releases valid? The court said, if there is a release procured from fraud or overreaching, they're not binding on a party who seeks to impeach them. And she showed enough that the defendant's persistence and their duplicitous efforts to obtain the releases were a result of her signing the releases, and therefore she has enough to show undue influence. This is another one. March, Roger Jacobs befriends Rose, and she's a decedent now. She was in her 70s and living alone, and she had been not paying her bills. She was living in filth. Her mental capacity kind of declined, and Roger assisted her around the house and drove her to various appointments. A few months after they met, he said, hey, you should hand me over your power of attorney. I can take care of things for you. Right? And on November 1988, now remember, March is when he befriended her, and now she executed a power of attorney as well as a new will that left all but her $268,000 estate to Roger. Okay? And Roger's second cousin happened to be an attorney, and he drafted the will. And They had actually a recording of her because they probably knew that this doesn't look kosher. And they said, well, she didn't completely lack confidence, but she had a weakened intellect. Okay. That's what the court said. When they were deciding whether she could rescind the contract based on undue influence, the court said it was established, the relationship was established by her dependency on Roger as well as the power of attorney, and he received the bulk of the estate. And her intellect was weakened because they could go back and look and say she couldn't even pay her bills. She was living in filth. She had all these things going on. And so what he did, he didn't coerce her, he didn't threaten her, he unduly influenced her. He used his persuasion. So now what you're going to do is do the first questions of your true false. And they're going to do with these two concepts. So you can write these down and then go and enter them in your quiz later where you got this assignment, or you can enter them. You might want to stop the video so you can get these questions down and have the answers. Number one, true or false, a contract signed under duress or undue influence is void. Number two, undue influence is when someone uses coercion to get another to enter into a contract. Now your quiz is only going to say question one, and you're going to put true or false for number one here. A contract signed under duress or undue influence is void. I did not write the questions down in the quiz because I want people to watch the video. And if someone can just go through and answer questions based on looking up at the internet or something like that, they're not really watching the video. So these are the first two of the 10 questions. Now we're going to take a moment to talk about misrepresentation versus fraud. Misrepresentation, we have innocent misrepresentation and we have fraudulent misrepresentation. Innocent misrepresentation is where an untrue assertion of fact is made. It's material to the reason the parties made the contract, and the party entered in the contract because of the reliance on that assertion was true, and the reliance by the complaining party was reasonable. Okay, meaning, hey, it wasn't some unreasonable thing. Fraudulent misrepresentation. So these are both untrue assertions, or they could be things that aren't said and they're not true. Innocent is that maybe you didn't do your due diligence. It's not a mistake. You made an assertion as if it was true, not really knowing that that was true. And maybe you had a belief that it was true. Fraudulent misrepresentation is an untrue assertion of fact. The assertion was fraudulent. The party entered into the contract because reliance on the fact, and the reliance by the complaining party was reasonable. What this means is with fraud, and what do you mean by an assertion being fraudulent? Meaning I had the mind to tell you, I knew difference. It wasn't just negligent misrepresentation. It was fraudulent. I knew, and I knew you wouldn't buy my house if I did or didn't tell you something, okay? In both of these cases, the consequences is it's voidable. So let's take a look. We've got Stambovsky versus Ackley, okay? And Stambovsky entered into a contract to purchase this home, and this is the actual picture of the home with Helen Ackley. Prior to the purchase, Stambovsky conducted the required home inspection and searched the records regarding the title. However, unknown to them, dun 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 dun, Ackley had held the house out to be haunted. There was an article in Reader's Digest about it, and the home was included on the home's tour. And she did not disclose. So what is this concealment, which is a form of misrepresentation or fraud? Upon learning that the home was haunted, then Stambovsky says, I want to rescind my sales contract, okay? This is actually called the Ghostbusters case because it was in 91 and the Ghostbusters was a popular movie. And in fact, the opinions the judge cites, you know, if there's a ghost in your house, who are you going to call? Ghostbusters. Anyway, the gist of it is that, first of all, there is this concept that we call caveat emptor. What caveat emptor says is, I don't have to, when I sell my house, disclose every single possible defect there could be to it. Buyer beware. That's what caveat emptor means. That means the buyer has a duty to do some due diligence as well. But it wasn't going to work in this case because the defect was in caveat emptor is something that if you do your due diligence, you'd be able to figure it out. But if this is really haunted, and by the way, they made a finding of fact or finding of law that it was haunted since she held it out to be. Okay, so we wouldn't discover it. And it was created by Ackley, and it was a condition that would not be discovered even under the most rigorous examination of the house. So it was created by the seller. It materially impaired the value of the contract, not because they were scared of ghosts necessarily, but because the value of their home probably wasn't what they believed it to be. If they went to resell it now, they have this haunted house they're trying to sell. Some people would say it's more, but you have a very limited crowd there. And if someone's unlikely, the seller or purchaser to discover it, then there has to be disclosure. Otherwise, non-disclosure constitutes a basis. This is misrepresentation by concealment. She should have told them. And even saying as is not going to work if the party knows it. So if the party knows something and they fail to disclose, or if they represent something to be something it's not, depending on their mind frame, it's going to be fraudulent misrepresentation or innocent misrepresentation, and the contract is going to be voidable. Here are your next questions. So you may want to pause. Misrepresentation may be based on claims of concealment if the seller knows of the defect but simply keeps quiet about it. Number 5, true or false. If the misrepresentation is innocent, the contract is not voidable. Number 6, innocent misrepresentation does not require that the assertion be false. Number 7, a person who commits fraudulent misrepresentation may be liable in tort for damages, including punitive damages. So our last section is unilateral versus mutual mistake. Mutual mistake, the mistake was a fundamental assumption. When you think of mistakes, think of assumption. We didn't misrepresent something either by being negligent about not doing what we were supposed to, or we didn't fraudulently misrepresent. We assumed that the fact was true, okay? So it was a fundamental we both thought something was true, and it affected the value of the agreement. And the defendant, the person who's saying they want out of the contract, did not assume the risk, meaning they did not say, well, I know this may not be true, or they didn't fail to do due diligence, right? And it would just be unconscionable to enforce the contract in light of the mistake. Unilateral mistake, same thing, a fundamental assumption, but it was by one person. It affected the value of the agreement, and that person did not assume the risk, and it would be substantially unconscionable. Here's the difference. Here's the kicker. It's a little harder to prove. Why? Because you have to prove one of the following: that the effect of the mistake is such that to enforce the contract would be unconscionable. So, or the other party knew or had reason to know, right, that you were assuming something that wasn't true, or the fault of the other party caused the mistake, okay? And what happens when we have mistakes? Here, they're voidable, but not always. There's one thing we can do. If it's what we call a Scrivener's error and the parties say, hey, we made this mistake in our documents or something, we can do what we do reformation. Or even if it's not a Scrivener's error, but we want to reform the contract. Maybe we made a mistake about the value of something. The parties can agree to reform, meaning rewrite that section of the contract. So, okay, we're going to take a look at a case using regarding mistake. B&W Financial Services versus Deloche. So Frank Deloche leases a vehicle from BMW and doesn't make any payments, and BMW repossesses the car. When they did that, they realized the odometer had been tampered with, so they sue him for breach of lease and tampering the odometer. BMW sold the car at auction for $25,000, but they didn't flag the account, and so the account was sent to a collection agency for approximate value of $24,000. Okay. And because there's still this ongoing litigation regarding the odometer. And so they should have just flagged the account, waited, let it play out. But instead, they sent it to a collection agency. And Delosha's father negotiates the settlement to pay $14,000 in exchange for a complete release of claims. And on August 17th, it was signed. But 4 days prior to that, BMW had won a default judgment in the amount of $114,000. So their default judgment 114, but he signs 3 days later with the collection agency a release for 14,000. Pretty good deal. Much of the amount was treble damages, which was based on the odometer tampering. But BMW doesn't learn of that settlement until after default judgment. And they said, wait a second, we're going to rescind the settlement because of the mistake in sending the account to a collection agency when it was pending. Okay. So the question then becomes, can BMW rescind the settlement agreement based on unilateral mistake? So the court said the following facts must be established, right? The defendant makes a mistake regarding a basic assumption upon which the defendant made the contact. It had a material effect upon the agreed exchange of performances. The defendant does not bear the risk of the mistake, and the effect of the mistake is such that the enforcement would be unconscionable. Now, the BMW did make a mistake regarding the basic assumption, which is that the account should go to the collections. And it had a material effect, right? Because by sending it to collections, it only had the amount that they were due for the balance of the BMW. The kicker here is the third one. The defendant does not bear the risk. And the court said it's reasonable under the circumstances to allocate the risk to BMW, and substantial evidence supports the conclusion. It was attributable solely to BMW Financial's failure to tag Delosha's account as being in litigation. So being sloppy, being lazy, not doing your due diligence is not going to be grounds for rescinding a mistake. Let's look at Renner versus Kell. They leased more than 1,000 acres of unimproved land and decided to sell the interests, the defendants, okay? And plaintiffs, Renner, said, hey, I want to purchase the land and I want to cultivate jojoba, which is what you see in the background of this PowerPoint. You make oil from it. And both parties believed there was sufficient water. And after drilling 5 test wells after the plaintiff bought it, they figured, oh no, there's not enough, so we want to rescind the agreement. And of course, the defendant said, no, we sold it to you. We want you to keep your agreement. So the plaintiffs have to sue for reimbursement of the purchase price. So the question becomes, can Renner rescind the settlement agreement based on mutual mistake? And when there's a mutual mistake, an essential part and condition of the contract, essential part, the contract may be rescinded. That's the basic law. And they intended the plaintiffs to use the leased land for the purpose of cultivating. Both parties assumed that there was a sufficient water and beneath the land, and both parties were wrong. It was a mutual mistake. After drilling, the plaintiffs discovered there wasn't enough water, and since both parties believed that that was the basic assumption on which they entered the contract, I mean, that is the material reason for the contract, the mutual mistake materially altered the very basis of the contract, and therefore the contract is voidable. Anderson Brothers, this is different versus O'Mara. Here's the difference. Anderson offered for sale a barge dredge that was designed for digging shallow trenches for Bering Pipeline. Robert O'Mara needed a dredge to dig wide, deep canals. O'Mara saw Anderson's advertisement and contacted an Anderson employee. And during the discussion, the employee assumed that O'Mara needed it for shallow digging. He didn't really say what he needed it for. He was just showing him. So, but O'Mara sends Kennedy, one of his employees, to inspect the dredge. And he knew a lot about engines, but not so much about dredges. But he inspects it anyway and assumes it's adequate and approves it. So after he gets it, he realizes it's not going to be suitable for the type of digging he needs. And so he wants to rescind the contract, and Anderson Brothers says, no, you're not going to be able to do that. And so the question goes all the way up to the court, and it says, The question is, can O'Mara rescind the settlement? Okay. So the question is there a mistake? Yes. Anderson was mistaken about what O'Mara was going to use the dredge. But Anderson didn't share that mistake. So there was no mutual mistake. What O'Mara was trying to argue was, hey, Anderson was mistaken about what we needed it for when I talked to their salesman. And I was mistaken about what it could do. And so those are a mutual mistake. Well, no, Anderson was mistaken about what he was going to use it for. O'Mara was mistaken about the capabilities, and that's not a mutual mistake. Those are two separate mistakes. And so the mistake was completely about something different. We don't have mutual mistake. What about unilateral mistake? Well, here we go. As to the dredge's capability was not grounds for recovery. Why? Because it was on him. Remember, the party was not assuming the risk. Just because he sent someone out there to look at it, to inspect it, was not enough due diligence. So therefore, the risk was on him. And so you have to ascertain facts that would prove that you made an effort and the risk was not, you weren't taking a risk on something. And that's exactly what he was doing by not knowing the capabilities. So here are the final true-false questions. Mutual mistakes may be remedied by reformation, true or false. It is more difficult to rescind a contract by unilateral mistake than mutual mistake, true or false. The parties do not have to be mistaken about the same fact for a mutual mistake, so long as both of the facts are material. So if you answer these 10 questions and submit your quiz for this lecture assignment, we will be covering chapter 14 next.